two individuals that decided to kill a child, and they did it methodically for 3 months. Impose the sentence that this case demands, and listen to Aniya Day's voice.
Thank
Thank you.
Anything further on behalf of the state?
Nothing, Your Honor.
Good. On behalf of the defense, Mr. Shaughnessy?
Thank you, Your Honor, for please the court. We're certainly mindful that any sentence that you impose here this afternoon is a life sentence. We would ask you to consider imposing a sentence that would entrust the parole board at some point in the future with determining if Sierra is suitable and acceptable for release. Judge, I'd ask you to find Sierra indigent for purposes of fines and costs, also indigent for purposes of appeal, and ask that she be appointed an attorney and an appellate transcript at state's expense. Thank you.
I assume your client does not wish to address the court.
She does not, Your Honor. Thank you.
Mr. Gay or Ms. Longino?
May it please the court.
You can remain seated, sir.
Oh, thank you. For me too?
You too.
Oh, thank you, Judge. First, I'd like to begin by sharing the pity that all of us feel for for the loss of this child. But the verdict is in. Deontay Lewis has been determined to be guilty of a number of criminal offenses, the most serious of which is aggravated murder. As counsel for the defendant, we take issue with the jury's decision as we believe the verdict is inconsistent with the evidence presented in this case. Mr. Lewis is 27 years of age and has no criminal record. It is well documented by daycare records that Aniya Day, the 4-year-old victim in this case, suffered abuse by her mother on a number of occasions long before these defendants ever met and began dating. It is also clear that Mr. Lewis did not reside with the mother of Aniya, had no clothes or other personal items on the premises to support the state's contention that he resided there, and notwithstanding the documented abusive history of the mother toward Aniya, Deontay Lewis was made to sit with the mother at trial as a co-defendant, which was highly suggestive and prejudicial toward his legal interests. In fact, if I was sitting next to Sierra Day during the trial, I believe I would have been convicted of something as well. Your Honor, the 38 sworn witnesses who gave testimony during the course of this trial, not one had anything to say that would call into question Mr. Lewis's character or conduct toward the child. Now we anticipate that Deontay Lewis will be sentenced to life in prison with parole eligibility after serving 20 years in accord with the Ohio Revised Code 2929.031B. Which includes the fact that there was no sexual motivation either in the indictment, and so that part is excluded. Nor did this young man have the history of sexual abuse or convictions. Your Honor, we contend that there was absolutely no proof beyond a reasonable doubt at trial, and presented in the trial of this matter, that would serve to reason in any fashion that this young man did harm to Aniya. And for that reason, we respectfully move this honorable court to enter an order dismissing all charges in this case against Deontay Lewis. Thank you very much, Judge.
Thank you. That request will be denied. Does your client wish to address the court? Please. Go ahead, sir.
You can sit there.
You can remain seated, rather. Excuse me.
I love Aniya. I truly do. I did not harm her at all, nor did I do anything to hurt her. Because God is my witness, I would never do anything to harm her. I keep my faith in God. I know He has my back, and I put all things in His hands. I'm gonna miss Aniya, and I love her. And right now, just I have to do what I have to do now. I thank you, your judge, and I thank everybody for listening.
Under the felony sentencing statute, the general principles are, the goal is to punish the offender and certainly protect the public. The other felony sentencing statutes are not applicable because aggravated murder is a separate felony which has different penalties than unclassified felony. The court has the option of imposing life sentences with parole eligibility after 20 years, after 25 years, after 30 years, or life with no parole. In deciding the penalty here, I've taken into the seriousness of the offense. And I don't believe in 24 years I've seen a more callous disregard for human life than I did with Sierra Day. She was offered help at various turns. She rebuffed the offers or misled those seeking answers or outright lied to them. Instead, she inflicted physical harm, which led to a series of strokes, which led to deterioration of organs and ultimately malnutrition. This was not a quick and relatively painless death, but a committed form of torture in my mind. I cannot temper justice with mercy with respect to her behavior. For that reason, she will receive a penalty of life without parole. She will have 3 years on county drunk concurrent. Mr. Lewis will receive a penalty of life with parole eligibility after 20 years, with 3 years on the count 8 to run concurrent. The tampering with evidence carries discretionary 3 years post-release control upon discharge from prison. Obviously, there's no post-release control on a life sentence. I will appoint appellate counsel for both defendants. They will have the opportunity to have a notice of appeal filed on their behalf without cost. They will have a right to a transcript at state's expense. They'll have credit for any time served. Sheriff to transport.